PVL3702, The Law of Contract, Chapter 5, Contractual Capacity. Number 5.1, Legal Capacity. All legal persons, whether natural or juristic, have legal capacity in the sense that as legal subjects they can be the bearers of rights and duties. This passive capacity stems directly from their legal personality and is not dependent upon their age or status. Thus, for example, even an infant, that is, a child under the age of 7 years, has the capacity to inherit and can acquire rights and duties under a contract concluded for it by his or her guardian. On the other hand, not all persons have the capacity to act in order to create, alter, or destroy rights and duties by performing juristic acts. A juristic act generally has certain chosen legal consequences for the person performing the act. Examples include the execution of a will and the conclusion of a contract. The extent to which a person has this active capacity depends upon his or her legal status, and in particular his or her age and mental competence. Since the performance of a juristic act is generally an expression of the actor's will, the law confers full capacity to do so only upon those whom it regards as sane, sober, and old enough to appreciate the nature and consequences of their actions. An infant, for example, has no capacity to perform a juristic act. Number 5.2. Contractual capacity. Contractual capacity is the competence to create rights and duties by concluding a contract with another person or persons. Since the conclusion of a contract is a bilateral or multilateral juristic act, the capacity to contract is merely one aspect of the wider capacity to perform juristic acts as discussed above. Accordingly, the extent to which a person has capacity to contract depends upon his or her ability to form and express a legally relevant will, which in turn depends upon the ability to appreciate the nature and effect of his or her act. As capacity falls under the law of persons, a comprehensive discussion is beyond the scope of this book. However, it is necessary to address basic aspects relevant to the conclusion of contracts. Number 5.3. Natural persons. All natural persons or humans have passive legal capacity, yet their status may differ depending on their attributes, for example, age, and circumstances, for example, insolvency. A person's status determines his or her contractual capacity. Natural persons can be classified into the following three groups. First, persons without contractual capacity. Secondly, persons with a limited contractual capacity. And number 3, persons with full contractual capacity. Number 5.3.1. Persons without contractual capacity. Persons whose mental faculties are so underdeveloped or impaired that they cannot appreciate the nature and consequences of their acts are entirely without contractual capacity. Infants, some persons who are mentally ill, and persons who are severely under the influence of alcohol or drugs fall into this category. A person under the age of 7 years is deemed to be unable to perform any juristic acts, and thus cannot independently conclude contracts. However, he or she can be the bearer of contractual rights and duties. To acquire such rights and duties, the child's guardian must act on his or her behalf, for example, by concluding a contract of sale for him or her. The infant obtains the rights and duties not by his or her own conduct, but by that of the parent or guardian. The latter may contract on behalf of the infant only for the purposes of administering the infant's estate, and for his or her maintenance and support. Certain contracts may never be concluded by the guardian on behalf of the infants, an obvious example being the engagement contract. Apart from infants, every person is generally presumed to have full mental capacity, unless someone claiming lack of mental capacity proves the contrary. Thus, a person who alleges that another person lacked contractual capacity at the time of conclusion of a contract must prove that, at, a, at the relevant time, the latter was incapable of appreciating the nature and effect of his or her actions. This is a question of fact. Where a person has been referred for treatment as a mental health care user by order of court, the order is prima facie proof of the lack of capacity. The burden of proof then shifts to the person alleging the presence of capacity to prove that the mental health care user did in fact have capacity at the time of conclusion of the contract. A person who lacks mental capacity can only acquire contractual rights and duties where his or her administrator concludes the contract in question on his or her behalf. The Consumer Protection Act states that any agreement with a person who has been declared mentally unfit by a competent court is void, where the supplier knew or could reasonably have determined this fact. The effect of this provision is not to deprive the consumer of his or her common law right to rely on the fact that at the time of the transaction he or she lacked the capacity to contract. Rather, the effect is to deprive the supplier of the right to prove that the consumer contracted during a lucid interval. In circumstances where the supplier knew or could reasonably have determined that the consumer was the subject of a court order declaring him or her to be mentally unfit. Intoxication may result in a temporary loss of contractual capacity, but only if a person was under the influence of alcohol or drugs to such a degree that he or she either did not know he or she was entering into the transaction at all or had no idea of its provisions. The mere fact that his or her judgment was impaired is not sufficient. If this test is satisfied, the contract is void ab initio and cannot be ratified. The burden of proof rests with the person who alleges the intoxication and the resulting absence of capacity. Number 5.3.2. Persons with limited contractual capacity. As a general rule, persons with limited contractual capacity can only conclude contracts with the assistance or consent of another person. The assistance or consent supplements the inadequate powers of judgment of the person who has limited contractual capacity. Number 5.3.2.1. Minors. A minor is a person between the ages of 7 and 18 years. Generally, a minor has insufficient capacity to incur binding obligations under a contract. To do so, the minor requires the assistance or consent of his or her guardian. Such consent will usually be given before or at the time of contracting, but may also be given afterwards by the guardian's subsequent ratification of the contract. The contract is then validated retroactively. Indifference does not amount to consent. Where the guardian refuses to consent, the guardian, as upper guardian of all minors, may upon application consent in the guardian's stead, or where the guardian has consented, it may set aside that consent. In some situations, a minor is regarded as being emancipated. This means that he or she is entitled to act independently in certain business transactions because the parent or guardian has given an express or tacit general consent to act as such without obtaining additional consent or assistance. The minor will then have full contractual capacity only for these specific juristic acts, provided that he or she has the actual ability to act independently. The consent given by the parent or guardian can be revoked at any time, in which case the status of the minor reverts to one of limited contractual capacity. Emancipation does not cause the minor to attain complete majority for all actions. If any transaction is to the minor's detriment, he will still be entitled to claim restitutio in integrum as discussed below. In certain cases, emancipation is forbidden by law. For example, where a statute expressly requires the consent of the parent or guardian, the master of the High Court or the court, as discussed below. However, a minor may, without the assistance or consent of his or her guardian, conclude a contract under which he or she obtains only rights and no duties. For example, a minor may validly accept a donation. There are also statutory exceptions to the general rule that the guardian's assistance is required. For example, a minor who is older than 16 years of age may deposit money in an account at a banking institution, provided that the constitution of the bank allows it, and a minor may independently contract for medical treatment that is to his or her benefit. Instead of lending assistance or consent, the guardian may personally enter into contracts for the minor. The minor and the rights and duties that arise from these contracts vest in the minor rather than in the guardian. The minor's consent or cooperation is generally not required. The minor is bound even if he or she does not know about these contracts. However, some contracts may never be concluded for the minor without his or her cooperation and consent. For example, the obvious engagement contract. In the case of certain transactions, not even the consent of the guardian will suffice to bind the minor. In addition, the consent of some official person or body is required. This where a minor's immovable property is alienated or encumbered, for example by a mortgage, the consent of either the High Court or the Master of the High Court must be obtained, depending on whether the value of the property is above or below 250,000 rand. Although the minor is bound by the contract where it has been concluded by or with the assistance of the guardian, the minor may nonetheless escape liability if it should later be shown that the contract was prejudicial to him or her at the time it was concluded. In that event, the court may, on application, set aside the contract and order restitutio in integrum. That is, restitution of both parties to the position they occupied prior to entry into the contract. The application may be brought before termination of minority by the guardian or with his or her assistance, or afterwards by the erstwhile minor himself. A claim for restitutio in integrum will be denied where the minor fraudulently pretended to be a major at the time of conclusion of the contract, where he ratified the act after attaining majority, or where the action has prescribed. The period of prescription is generally 3 years for a contractual claim unless specified otherwise by statute, but is subject to delay where the creditor is a minor. Minority is one of the impediments that delay the completion of prescription. In terms of Section 13 of the Prescription Act, prescription will continue to run during the existence of an impediment, but the period of prescription shall not be completed until 1 year has passed from the date on which the impediment ceased to exist. The minor's claim for restitutio in integrum will thus prescribe at the earliest 1 year after the minor has attained the age of majority. This is discussed under termination of contractual relationships below. On attaining majority, the erstwhile minor can elect to repudiate or to ratify any contract that he or she concluded during minority without the necessary assistance or consent of his or her guardian. Ratification has retroactive effect. The unauthorized contract will then be deemed to be valid and binding from the date of its conclusion. Where the minor has acted without the necessary assistance or consent, the contract cannot be enforced against the minor, but it is not void because it can be enforced against the other party, provided the minor is willing to fulfill his or her side of the bargain. If the guardian assists the minor in claiming performance from the other party, the guardian will still have ratified the contract. In the absence of such ratification, the minor has to return any performance he or she already received from the other contracting party. Where the performance has been destroyed or alienated or has depreciated in value, the other party may have a claim against the minor on the grounds of unjustified enrichment. He or she may also have a claim for damages in delict, if the minor fraudulently misled the other party into believing that he or she had the necessary capacity to contract. In terms of the Consumer Protection Act, an agreement to enter into a transaction with a consumer who is or was at the time an unemancipated minor is voidable at election of the consumer unless the agreement was, first, made with the consent of an adult responsible for the minor, or secondly, has been ratified by such an adult or by the minor himself or herself upon attaining the age of majority. The same applies to an agreement for the supply of any goods or services to or at the direction of an unemancipated minor. The consumer loses the right to set aside the agreement where the consumer or any other person acting on his or her behalf by act or omission led the supplier to believe that he or she had unfettered legal capacity to contract, or attempted to obscure or suppress the fact that the capacity was absent. Number 5.3.2.2 Married persons. Spouses married out of community of property have separate estates and their contractual capacity is unaffected by the marriage. This will be the case where the parties concluded an antenuptial agreement verbally or in writing prior to their marriage. Where the contract is in writing, has been signed and is notarially executed and registered in the deeds office within 3 months of the date of marriage, it is also binding upon third parties. Spouses married in community of property, on the other hand, have a joint estate and their capacity to bind that estate is limited by statute. As co-owners in equal undivided shares, they administer the joint estate concurrently, much like partners. That is to say, both husband and wife have the ability to perform juristic acts and equal powers to manage the joint estate. By and large, these powers can be exercised independently, without the consent of the other spouse. Certain transactions, however, are deemed so important that they can be concluded by a spouse only with the consent of the other. The Matrimonial Property Act prescribes the transactions or juristic acts in respect of which informal consent, either express or tacit, written consent, or written consent attested by 2 witnesses is required. Consent may, in certain cases, be given after the transaction by way of ratification. Where a spouse has concluded one of these transactions without the required consent and the other contracting party was not aware and could not reasonably have been aware that the spouse's consent was required, the joint estate is held bound to the contract. Upon dissolution of the marriage through divorce or death, any loss caused by the conclusion of the unauthorized contract can be recouped from the contracting spouse's share of the joint estate. Where a spouse married in community of property has a separate estate, for example, property inherited under a will stipulating that the property should not fall into the joint estate, he or she has full independent contractual capacity in respect of that separate estate. Number 5.3.2.3 Insolvent persons. The mere fact that a person is insolvent, in that he cannot pay his or her debts or the person's liabilities exceed his or her assets, does not affect contractual capacity. Only once a court has granted an order of insolvency placing the person's estate under sequestration in his or her capacity is his or her capacity limited. Upon sequestration, the insolvent estate vests in a trustee whose function it is to wind up the estate for the benefit of the estate creditors. During the sequestration, the insolvent may still validly enter into contracts, provided that he or she does not purport to dispose of any of the assets of the insolvent estate. Furthermore, the insolvent requires the written consent of the trustee for any contract that is likely to affect the insolvent estate adversely. Contracts entered into by the insolvent prior to sequestration that benefited one creditor above the others, or under which the insolvent disposed of property for no value in return, may be set aside for the benefit of the general body of creditors. Okay, number 5.3.2.4 Prodigals. A prodigal is a person with normal mental ability who, through some defect of character or will, squanders his or her assets irresponsibly so as to threaten to reduce him or herself and dependence to penury. Such a person may be declared a prodigal by a court whereupon his or her contractual capacity resembles that of a minor. The administration of a prodigal's estate is placed in the hands of a curator, whose assistance and consent is required for any contract that imposes obligations upon the prodigal. Contracts concluded by the prodigal without the requisite assistance or consent are voidable, rather than void, and can thus be ratified by the curator. Similarly, persons for some reason, such as disability or illness, are unable to manage their own affairs may be placed under curatorship by order of court. Number 5.3.3. Persons with full contractual capacity. As a general rule, all natural persons falling outside the above-mentioned categories have full capacity to enter into contracts. In certain respects, however, specific statutory provisions may limit their capacity. For example, a person who has been found guilty of a crime involving dishonesty, such as fraud, is disqualified from being appointed as a company director. Number 5.4. Juristic persons. A juristic person is an artificial entity with no physical existence, upon which the law confers legal personality. That is, the capacity to acquire rights and incur obligations. The chief examples are companies, closed corporations, also bodies incorporated by statute, such as the South African Broadcasting Corporation, the SABC, universities, and the governing bodies of public schools. And lastly, certain voluntary associations, such as clubs, societies, and the like, that display the essential characteristics of a corporation, namely perpetual succession of its members and having rights and duties in its own name, separate from that of its members. It is important to note that partnerships, joint ventures, and divisions of corporations are not juristic persons endowed with separate legal personality, nor are trusts, though in practice they are often created as separate entities. In law, the assets and liabilities of a trust vests in the trustees of the trust in their capacities as trustees, and it is they who contract in the name of the trust. Note, however, that trusts and partnerships are sometimes deemed to have legal personality for the limited purposes of certain statutes. In the very nature of things, a juristic person cannot have full legal capacity or powers of a natural person. For example, it cannot adopt a child, marry, or be appointed as the guardian of a minor. Its rights and powers, including its capacity to enter into contracts, are determined and limited by the terms of its constitutive documents. For example, a statute, a charter, a constitution of a club, the founding statement of a closed corporation, or the memorandum and articles of association of a company. Anything done, and in particular any contract concluded outside the scope of its powers, is said to be ultra vires and devoid of legal effect. Since 1973, however, this is no longer true of companies. Since Section 36 of the previous Companies Act, no act of a company was void by reason only of the fact that the company was without capacity or power to perform the act. Since a juristic person has no physical existence, it can act only through its organs or representatives. The latter are always natural persons. Only those natural persons who have the necessary power or authority to represent the juristic person can bind it by performing juristic acts on its behalf. For example, where ABC Proprietary Limited, a company, wants to buy a piece of land on which to erect an office block, a deed of sale has to be drawn up and signed by the parties to the contract. As the company is an immaterial entity that cannot physically sign a document, the deed will be signed by one or more directors or officers of the company in a representative capacity. Number 5.5. The state. The state and its organs have the capacity to enter into contracts. The source of this power, in the absence of any specific enabling statutory provision, is the common law prerogative. When the state contracts, it may be held liable to perform its obligations under the contract in terms of the State Liability Act, provided that the act was entered into in the ordinary or necessary course of government administration, and was directly or indirectly authorized by the responsible minister. By reason of the position that it occupies in public law, however, the state cannot in all respects be treated on the same footing as any other contracting party. This, for example, although there is some uncertainty about the scope of this principle, where discretionary powers have been conferred upon a public authority, those powers must be exercised in accordance with the principles of public law. Any contract entered into by the public authority that purports to fetter the exercise of its discretionary powers will not be enforceable. Nor can the state by contract abdicate its discretionary powers to others. Furthermore, when it comes to the the exercise of its contractual powers, the state might be held to a higher standard than an ordinary private party, since it might have to act in accordance with principles of administrative justice. Lastly, various statutes and regulations relating to tender procedures and procurement policies, which can impact the ability of the state to contract freely in a commercial sphere, bind the state. PVL 3702, The Law of Contract, Chapter 6, Formalities. Number 6.1, Introduction. As a general rule, no formalities are required for the formation of a valid contract. Provided all the other requirements for validity are met, the parties may thus express their intentions in whatever form they wish. There are two exceptions to this general rule. First, in respect of certain types of contracts, the law may require that the parties express their intention in a prescribed formal way. Such statutory formalities include writing, notarial execution, and registration. And secondly, the parties themselves may agree that their contract will be binding on them only when certain formalities have been observed, usually in the form that the agreement be reduced to writing and be signed by the parties. They might also prescribe similar formalities for any variation or consensual cancellation of the contract, or for any waiver of rights arising from the contract. It is generally advisable to put important contracts into writing to facilitate proof of their existence and terms. The party who wishes to enforce a contract bears the onus in this regard. Without a written record of the agreement, proving the terms might be difficult after the passage of time or when the contract is complicated. Number 6.2. Formalities prescribed by law. Various statutes require that certain types of contracts should comply with prescribed formalities. These formalities usually require that the contract be in writing and be signed by one or more of the parties, and sometimes that the contract should be notarially executed and registered if it is to be effective against third parties. Certain statutory provisions also apply to formalities in electronic contracts. The most important instances are mentioned below. Although many different policy considerations underlie the setting of formalities, each statute has its own objectives that are also used to interpret its provisions. Although the wording of each statutory provision prescribing writing as a formality determines the actual scope of the provision, the following general comments may be made. First, that all the material terms of the contract must be in writing, not just the essentialia. Secondly, in terms implied by law, naturalia obviously need not be in writing. Tacit terms also do not need to be in writing. And third, the terms do not all need to be in one document. Number 4. Any variation of the material terms of the contract has to be in writing to be effective. There is a tendency to water down this rule by restrictively interpreting the statute in question. Where a subsequent agreement does not amount to a variation of the contract, the agreement may be oral. This is the case where the variation grants an extension of time or the parties cancel their contract, and where the parties to a cancelled contract of sale of land revive the cancelled contract. Number 5. Sometimes a party misleads the other party by agreeing to an oral variation of the contract, only later to rely on the formal invalidity of the variation of their contract. May the misled party raise the defense of estoppel? The defense of estoppel will not usually succeed here, because estoppel may not be used to achieve a result that is contrary to law, that is, an oral variation that is contrary to statutory prescription. And number six, if the formalities are not complied with, the contract is void. Any performance in terms of a void contract may be recovered with one of the enrichment actions recognized by our law. However, in Carlos versus McCusker, the court developed a new enrichment action that allowed for the recovery of performance in the case of a formally defective alienation of land, but without any of the technical requirements of the other enrichment actions. The recipient of the performance may defeat the enrichment action by performing or tendering to perform his or her obligations in terms of the void contract. This case was followed by other Transvaal decisions, but it was rejected by the Cape Provincial Division and severely criticized by commentators. The Appellate Division held in Vulcan versus Koller that no enrichment action was available where both parties had performed fully. The legislature intervened in 1981 by creating a special enrichment action and providing further that where the person to whom the land has been alienated has performed fully and where the land has been transferred to this person, the alienation is valid from the beginning, even though the contract does not comply with the prescribed formalities. Okay, number 6.2.1. Prescribed formalities required for validity. The law requires certain types of contract to be in writing and to be signed by the parties in order for the contracts to be valid. Failure to adhere to the prescribed formalities in these cases will render the contract void. Number 6.2.1.1. Alienation of land. Section 2, subsection 1 of the Alienation of Land Act provides no alienation of land after the commencement of this section shall be of any force or effect unless it is contained in a deed of alienation signed by the parties thereto or by their agents acting on their written authority. Alienation includes sale, exchange, and donation. The purpose of the legislator is to promote legal certainty regarding the authenticity and contents of contracts, thereby limiting litigation and preventing malpractices such as fraud. And then there's a small pause for reflection. Applicability of Alienation of Land Act depends on identifying type of contract. If a contract is a sale, exchange, or donation of land, it must comply with the formalities set by the Alienation of Land Act. Each type of contract is characterized by its essentialia. We thus have to determine whether the terms of the contract in question have the essentialia of sale, exchange, or donation of land. If they do, the contract has to be in writing and must be signed by the parties. A sale is an agreement in which one party undertakes to deliver a thing in exchange for a price. Exchange is an agreement in which one party undertakes to deliver a thing to another party in exchange for the counter delivery of another thing. A donation is a contract in which the donor undertakes to deliver a thing to the donee out of sheer liberality or disinterested benevolence and without any counter performance. That's the end of the pause for reflection. If someone signs on behalf of a party, he or she must be authorized in writing by that party to do so. This requirement does not apply where a company signs through one of its organs, for example, its managing director, as the organs are not agents of the company. A company can, of course, act through an agent, in which case the agent must be authorized in writing by the company. The provisions of Section 2 do not apply to the sale of land by auction. However, where the purchase price is payable in more than 2 installments over a period of more than 1 year, an installment sale, the conditions of sale must be read in public immediately before the auction, and the seller must provide the purchaser with a copy of the contract of sale immediately after the auction. Number 6.2.1.2. Suretyship. Suretyship is a contract in terms of which the surety undertakes to the creditor of the principal debtor that if the principal debtor fails to perform the principal obligation, the surety will perform it, or failing that, will indemnify the creditor. Section 6 of the General Law Amendment Act provides that no contract of suretyship entered into after the 22nd of June 1956 is valid unless its terms are embodied in a document signed by on behalf of the surety. The creditor need not sign. The same policy considerations that are relevant with regard to the alienation of land are applicable here. A further possible purpose is to bring the terms of the contract to the attention of the surety because the onerous obligation of the surety should the principal debtor fail to perform. Okay, and then there's a small counterpoint. Formalities prescribed by statute may cause problems of their own. Litigation on legislation that prescribes writing as a formality has been so frequent that it is clear that such formalities do not solve every uncertainty, litigation, or malpractice. Required formalities sometimes even cause these problems or invite them. Even where writing is used as a method to inform consumers of the contents of their contracts without requiring it as a formal requirement, for example, the Housing Consumers Protection Measures Act and the National Credit Act, the purpose of the legislator is not always achieved. Many people still sign standard form contracts without reading them. Okay, that's the end of the counterpoint. Then number 6.2.1.3, donation. Section 5 of the General Law Amendment Act provides that no executory contract of donation entered into after the 22nd of June 1956 will be valid unless its terms are embodied in a written document signed by the donor or by a person acting on the donor's written authority granted in the presence of two witnesses. The deed of donation itself does not have to be witnessed. The donee has to accept the offer but need not sign the contract. An executory donation is one that has not yet been carried out, that is, has not been completed by delivery of the promised benefit. The purpose of this provision is apparently to make sure that the donor has a serious intention to conclude the contract. However, an oral donation completed by delivery of the benefit is a binding contract. Number 6.2.2. Prescribed formalities required for enforcement against third parties. Certain formalities are not requirements for the validity of the agreements in question as between the parties to the agreement. However, a party will not be able to rely on the contract or be able to enforce it against third parties unless certain formalities have been observed. Such formalities are aimed therefore at bringing the contract in question to the notice of third parties. Number 6.2.2.1. Antenuptial contracts. An oral antenuptial contract is valid between the parties, but it has to be notarially executed and registered within 3 months to have effect against third parties. Notarial execution entails the conclusion of the contract in writing in the presence of a notary. The notary then signs the document, seals it, and places a copy of it in his or her protocol, the place where he or she keeps all the documents he or she executes. Number 6.2.2.2. Long leases of land. Section 1 of the Formalities in Respect of Leases of Land Act provides that an oral lease of land is valid, but that a long-term lease of land only has effect against a creditor or successor under honoris title of the lessor for a period of longer than 10 years after having been entered into, if it has been registered against the title deed of the leased land. Third parties will also be bound if they knew of the long lease because of the operation of the doctrine of notice. Okay, number 6.2.3. Formalities in electronic contracts. Section 12 of the Electronic Communications and Transactions Act provides that a requirement in law that a document or information must be in writing is met if the document or information is in the form of a data message and is accessible. This provision does not apply to alienations of land and agreements for the long-term lease of immovable property in excess of 20 years. However, it does apply to suretyships and to executory donations of anything but land. It seems that Section 12 applies to formalities required by a statute as well as to those required by the parties. Section 12 should also apply to any variation of a contract. Section 13, subsection 2 of the Act provides that an electronic signature can now serve as the functional equivalent of a wet signature. Electronic signatures can take a variety of forms and, depending on the nature of the transaction, could range between simply writing a person's name at the end of an email message to the use of a complex biometric identification technologies. However, where the signature of a person is required by law but without specifying the type of signature, that requirement in relation to a data message is met only if an advanced electronic signature is used. An advanced electronic signature is defined as an electronic signature resulting from a process that has been accredited by the Director General of the Department of Communications, acting as the accreditation authority. Number 6.3. Formalities stipulated by the parties. The parties may themselves prescribe formalities for the creation, variation, or cancellation of their contract. Neither party may depart unilaterally from these formalities. Number 6.3.1. Creation of the contract. The parties to an oral agreement will often agree that their agreement should be reduced to writing, and perhaps also be signed. In doing so, they may have either of the two very different purposes in mind. First, the parties may wish to have a written record of their agreement merely to facilitate proof of its terms. If so, the agreement is binding even if it is never reduced to writing. And number 2, alternatively, the parties may intend that their oral agreement will not be binding upon them until it is reduced to writing and signed by them. In this case, the prior oral agreement lacks contractual force and will become a contract only if or when there is compliance with the stipulated formalities. Neither party can compel the other to sign the agreement. Which of these two purposes the parties had in mind is a matter of fact. In the absence of contrary evidence, the law presumes that their intention was merely to facilitate proof of the terms of the agreement. The party who alleges otherwise, namely that writing was intended as a formal requirement for the validity of a contract, bears the onus of proving such an intention. The leading case is Goldblatt versus Fremantle. F undertook orally to supply G with lucerne at intervals. The parties agreed that F would reduce their oral agreement to writing and that G would confirm it in writing. F set out the terms of their agreement in a letter and asked G to confirm the terms in writing. When G failed to do so, F stopped supplying G with lucerne. G claimed contractual damages from F. The appellate division held that no contract existed because the parties intended their agreement to be concluded in writing, which also involved signing by both the parties. In De Bruin versus Brink, the court held that such intention could not arise from an agreement to merely embody terms which had previously been verbally agreed upon in a written document, as such an undertaking would be quite consistent with the intention to be bound by the verbal agreement. The intention of the parties with regard to what in writing means is of course decisive, but in the absence of evidence about the intention, the conclusion of an electronic contract that complies with the requirements of Section 12 of the Electronic Communications and Transactions Act, that is, the contract in the form of an accessible data message, should usually comply with the stipulated formality of writing. And then there is just figure 6.1 that you can study on your own time. And then they say, even if the intention of the parties was that there should been no binding contract until the agreement was reduced to writing, there is nothing to stop them from changing their minds and scrapping the requirement of writing, in which case the oral agreement would immediately acquire contractual force, and they might do so expressly or tacitly. Number 6.3.2 Variation of the contract, non-variation clauses and the Chiffrin principle. The parties to a contract may also prescribe certain formalities for any variation of their contract. In fact, it has become an extremely common practice to insert a non-variation clause in any written contract, the standard wording being more or less as follows. No variation of this agreement shall be of any force or effect unless reduced to writing and signed by the parties to this agreement. There used to be some doubt as to whether parties could restrict their freedom to amend their contract orally this way, but these doubts were put to rest by the Appellate Division in 1964, in the well-known case of SA Sentrale Coöperatiewe Graanmaatskappy BPK versus Chiffrin. The court held that a non-variation clause was not against the public policy and that no oral variation of the contract was effective if the clause entrenched both itself and all the other terms of the contract against oral variation. The purpose of the clause was to prevent disputes and problems of proof that might otherwise arise if oral variations were permitted, and it operated in favor of both parties. Giving effect to the clause was in line with a fundamental principle of pacta sunt servanda. Agreements that are freely and seriously entered into must be enforced in the public interest. Although the same might be argued with regard to the subsequent oral variation, the point was that by inserting the non-variation clause, the parties had themselves limited their powers to vary their contract by binding themselves to a formal procedure for any such variation. The clause did not deprive them of their freedom of contract, since they could still freely vary their contract, provided that they complied with the formal requirements they themselves had agreed upon. In practice, however, the application of the Chiffrin principle can produce results that appear to be unjust. For example, a landlord may orally agree that the tenant may pay the rent late, but then later cancel the contract on this ground, relying on the non-variation clause. This has led many courts over the years to attempt to soften or even circumvent the Chiffrin principle by invoking doctrines relating to waiver, estoppel, a pactum de non petendo, and good faith. More recently, the principle was directly challenged, partly on constitutional grounds, in what is now the leading case on the subject, Brisley versus Juristic. However, the Supreme Court of Appeal unanimously reaffirmed its earlier decision in Chiffrin. The courts explained why the courts attach preference to the parties' original exercise of their freedom of contract by referring to the analogous instance where the legislature or parties prescribed writing as a formal requirement for a contract. A non-variation clause operates for the benefit of both parties, the court said, and does not detract from constitutional considerations of equality. And then there's a small counterpoint. Should freedom of contract not mean that we are free to change our minds despite the existence of a non-variation clause? The enforcement of a non-variation clause is explained by the self-limitation of the parties of their freedom of contract. Conflicting views are held on the cognizency of this argument. Some regard this argument as logical, but others think that this argument cannot explain the preference given to the non-variation clause over the subsequent oral variation. Freedom of contract indeed demands that the parties should be able to alter an earlier agreement by a later one. However, the enforcement of the non-variation clause can be explained by the principle of commercial certainty and the avoidance of litigation. That is, that this is indeed so was recognized in Brisley versus Trotsky, where the preferential principle was identified as legal certainty or commercial reliance and social certainty. Of course, legal certainty is one of the underlying principles of the law of contract. Okay, and then number 6.3.3. Cancellation of the contract. Non-cancellation clauses. The general rule is that parties are free to cancel their contract at any time by mere agreement. However, since parties can effectively prescribe formalities for the creation and variation of their contract, it seems logical that they should also be permitted to do so for the cancellation of the contract. And this proposition was indeed accepted as correct in the leading case of Impala Distributors versus Taunus Chemical Manufacturing. As with non-variation clauses, it has become standard practice to insert a written contract a non-cancellation clause, prescribing certain formalities, usually writing and signature, for the cancellation of the contract. Such a clause is restrictively interpreted and applies only to consensual cancellations, that is, to situations where the contract is terminated by mutual consent. It will not prevent a party from cancelling the contract unilaterally on the grounds of breach of contract by the other party. In the Impala case, the non-cancellation clause stated, "This agreement may be terminated by mutual consent in writing of the parties." The contract also contained a non-variation clause. The court held that but for the non-variation clause, the parties would have been free to vary the non-cancellation clause informally by dropping the requirement of writing. The addition of the non-variation clause had the effect of entrenching both itself and the non-cancellation clause against oral variation. In order to be effective, therefore, a non-cancellation clause must be coupled with a non-variation clause. The standard wording today is this: "No variation or consensual cancellation of this contract shall be of any force or effect unless reduced to writing and signed by the parties." The court in Impala went still further by suggesting obiter that a non-variation clause on its own would prevent an oral cancellation of the contract, but this is open to doubt. Number 6.3.4. Limiting the Chiffrin principle. As noted earlier, the application of the Chiffrin principle can sometimes have consequences that are unsatisfactory. Consider the following example, which is by no means uncommon. A lessor and lessee orally agree to reduce the amount of the rent from 3,500 Rand to 3,000 Rand per month, despite the existence of a non-variation clause in their written contract. When the lessee reminds the lessor of the need to reduce this variation to writing, the lessor assures the lessee that he regards himself bound by the oral agreement. The contract also contains a clause providing that the lessor may cancel the contract for any breach by the lessee, including a failure to pay the full amount of the rent. The lessor accepts the reduced rent for 4 months, but when the lessee again tenders 3,000 Rand in the 5th month, the lessor cancels the contract without any prior warning and claims payment of the full 3,500 as well as 2,000 Rand, that is 500 Rand per month arrear rental. Faced with unconscionable conduct of this sort, courts have sought to limit the application of the Chiffrin principle in various ways. Number 6.3.4.1. Restrictive interpretation. A non-variation clause must be restrictively interpreted because it curtails the parties' freedom of contract. Whether such a clause protects itself against oral variation is a question of interpretation in each case. The standard form of this clause certainly entrenches itself, and this would probably apply to most versions of the non-variation clause. A non-variation clause prescribes formalities only for the variation of the contract. A variation is a bilateral consensual act by which the parties change the terms of the contract. Any legal act that does not amount to a variation is unaffected by the non-variation clause. On the basis, it has been argued that an informal cancellation of a contract is valid despite the presence of a non-variation clause because cancellation, whether by agreement or unilaterally for breach, extinguishes rather than varies the contract. Certain forms of waiver also do not amount to variations, and hence fall outside the scope of the Chiffrin principle. Waiver is the abandonment of a legal right by the right holder with full knowledge of the existence of the right. Such abandonment can take various forms, some consensual, others unilateral. This makes drawing the line between waiver and variation an often difficult exercise. Attempts by litigants to construe an informal variation of the contract as a waiver of the right to rely on the non-variation clause have not met with success. On the other hand, the following forms of waiver have been held not to constitute variations, and therefore do not fall foul of a non-variation clause. Number 1. Waiver of an accrued right arising from breach of contract, for example, of the right to cancel the contract or to claim damages. Secondly, the discharge of an accrued obligation to make a certain performance under a contract by the creditor's acceptance of a substituted performance, datio in solutum, or by his or her releasing of the debtor from the obligations. And number 3, an agreement not to enforce a right accruing under a contract, at least for a limited period of time, a pactum de non petendo. For example, a promise by a creditor not to cancel the contract if the debtor fails to perform its obligations on time. These exceptions may be illustrated by reference to the example in number 6.3.4 above. The oral agreement between the lessor and the lessee clearly amounts to a variation of the lease because the agreement purports to change the lessee's obligation to pay 3,500 Rand rent per month. This oral variation cannot be given effect due to the non-variation clause. Accordingly, the lessee's obligation remains to pay the full amount of 3,500 Rand every month. On each occasion that she fails to do so, she commits a breach for which the lessor is entitled to cancel the contract. However, every time the lessor accepts the lesser payment of 3,000 Rand, he abandons or waives the right to cancel the contract for that particular breach. Moreover, by accepting the lesser amount in full discharge of the obligation to pay the rent for that month, he waives the right to claim the shortfall of 500 Rand. The waiver in this instance takes the form either of a partial release of the debtor from her obligation or the acceptance of a substituted performance in lieu of that which was originally owed. Either way, the lessor is precluded from recovering the amount of 2,000 Rand as arrear rental. However, he may recover 3,500 Rand rent in respect of the 5th month of the lease, since on that occasion he did not accept the lesser amount tendered by the lessee. The tender of reduced performance in the 4th month is a breach of contract by the lessee, and the lessor may unilaterally cancel the contract without complying with any formalities. However, permitting the lessor to cancel the contract in these circumstances, after agreeing to and then accepting reduced performance for 4 months, strikes one as unconscionable. One could perhaps argue that by his conduct the lessor implicitly agreed to a pactum de non petendo, that is, an agreement not to enforce his right to cancel, or at least not to cancel without due warning that in the future he would be insisting upon strict compliance with the contract. Two other possible remedies present themselves. The defense that the enforcement of the non-variation clause in the circumstances would be contrary to public policy, and estoppel. Number 6.3.4.2, where enforcement would be against public policy. A non-variation clause will not be enforced where enforcement would be contrary to public policy. Some examples are listed below. First, where a party fraudulently relies on the clause, it seems the clause will not be enforced. Secondly, the fact that the creditor acts in bad faith by attempting to enforce the clause does not in itself mean that such enforcement is against public policy. In Brisley versus Trotsky, the Supreme Court of Appeal held that a court cannot refuse to enforce a contractual provision simply on the basis of good faith, since good faith is not a free-floating principle capable of independent application. Rather, it is an underlying value that informs the various rules and principles of the law of contract, including the rules regarding illegality. Accordingly, the test is not whether enforcement of the non-variation clause would be in bad faith, but rather whether it would be contrary to the public interest. And lastly, the fact that enforcement would be unfair is apparently relevant in determining whether or not a variation clause would be against public policy. In Brisley versus Trotsky, the court assumed, without deciding, that the sus-fin principle could be extended to the enforcement of terms. This suggests that enforcement would not be permitted in circumstances where it would be so unfair as to be detrimental to the interests of the community. The power to declare the enforcement of a clause contrary to public policy should be exercised sparingly and only in the clearest of cases. The court then applied the sus-fin principle to the facts of the case. The contract of lease contained a non-variation clause. The lessor accepted late payment of the rent by the lessee for 5 months in accordance with an oral agreement concluded by the parties after conclusion of the contract of lease. The lessor then exercised a contractual clause that allowed him to cancel the contract for late payment. The court found that the lessee's case fell far short of the requirements of exceptional unfairness. Firstly, the lessor merely enforced the non-variation clause for its initial purpose of avoiding disputes. To uphold the lessee's defense would create a loophole that would allow a dispute to be raised. And secondly, certain contractual terms expressly excluded reliance on waiver and estoppel. And thirdly, the lessor could have cancelled the contract upon the first late payment, and so it could not be said that the lessee was worse off because of the acceptance of a number of late payments. In a number of subsequent decisions, the Supreme Court of Appeal has expressly rejected the interpretation of the Constitutional Court in Barkhuizen versus Napier as authority for the view that fairness is a freestanding requirement for the exercise of a contractual right, but nevertheless went ahead and inquired whether the cancellation of the contract was unreasonable and unfair. Later Constitutional Court cases have failed to bring clarity in this regard. The High Court, however, has extended the public interests that are relevant in determining whether the enforcement is against public policy. In 3 cases, the court found that enforcing the non-variation clause would unreasonably limit a public interest and thus be against public policy. In Nyandendi Local Municipality versus Halazo, excuse my pronunciation, a municipal manager freely participated in his disciplinary hearing and never challenged the finding that he was guilty of the charges. The holding of a disciplinary hearing amounted to an amendment of his employment contract. The High Court held that his enforcement of the non-variation clause amounted to an abuse of the process of law because the manager had no bona fide defense to the charges and his only purpose was to delay his dismissal. This infringed the municipality's rights under Section 34 of the Constitution. In GF versus SH, the High Court refused to give effect to a non-variation clause in a divorce settlement agreement, which had been made an order of court, because such enforcement would not be in the best interests of the children. The amendment of the residency arrangement and maintenance of the minor children was negotiated through mediation. The best interests of the children is a constitutional value. In Steyn versus Karee Kloof Melkery Proprietary Limited, numerous disputes arose between the parties soon after the sale of a farm and the dairy business. The first settlement agreement complied with the non-variation clause, but the second one did not. The High Court identified 3 public policy considerations, 2 of which were not protected constitutional values, and refused to enforce the non-variation clause because it would be against public policy. In two other cases, the High Court considered the possibility of other public interests, but found that none existed and came to the conclusion that the non-variation clause should be enforced. On appeal in the Supreme Court of Appeal in SH versus GF, the court was critical of the decision of the court a quo in an obiter remark. The court pointed out that the policy considerations that the court a quo relied upon were precisely those that were weighed up in the Schifrin case, where the court found that non-variation clauses were valid. This seemed to put an end to the expansive development in the High Courts. The Constitutional Court has, however, not expressed its view on this issue yet. Number 6.3.4.3. Where a party is stopped from enforcing a non-variation clause. The courts have recognized the possibility of raising the defense of estoppel, but there is no reported case where it has been successfully raised on the facts. The area of operation of estoppel is also uncertain. The defense of estoppel will clearly not succeed where the parties have varied the contract by oral agreement. One of the requirements for estoppel is that the representation must be such as to lead a reasonable person to believe that he or she might act safely thereon. It is usually unreasonable to believe that an oral variation will be binding where there is a non-variation clause in the contract. Where one of the parties unilaterally misrepresents that he or she will not rely on the non-variation clause, writers hold conflicting views on the scope of application of estoppel. One view limits the application of estoppel to cases where the upholding of estoppel does not amount to an informal variation of the contract. This will be the case where one party makes a misrepresentation to the other party that the latter has performed or discharged an obligation, or that the former party will not enforce his or her right. The opposing view does not limit the scope of estoppel's application in this way because a non-variation clause usually only applies to the amendment of the terms of the contract by agreement between the parties. Okay, and then there's a counterpoint. Reliance on estoppel may be unnecessary. It has been argued that in many instances where estoppel could possibly be raised, it is in fact unnecessary to do so, because the obligation has either been discharged by release or datio in solutum, or because a pactum de non petendo has been concluded. A pactum de non petendo can be present where the parties had the intention to conclude such an agreement, or where the lessor conducted him or herself in such a manner that the lessee was misled into thinking that the lessor had the intention to conclude such an agreement, and a reasonable person would also have been thus misled. That is a reasonable reliance. The contract of release is not changed in any of the above instances. Number 6.3.5. A non-waiver clause. The drafters of contracts were quick to notice that waiver might afford a means of escape from the Schifrin straitjacket. Accordingly, it is now standard practice to include in written contracts yet another clause, a non-waiver clause, which is to the effect that no latitude or indulgence shown or extension of time granted by the creditor or any particular occasion should be construed as a waiver of his or her right to insist upon strict compliance with the terms of the contract, or of his or her remedies in respect of any prior or subsequent breach of the contract. Such a non-waiver clause is valid and effective, but is strictly construed by the courts. Depending on its wording, it might also preclude any reliance on the doctrine of estoppel. And then you can just study table 6.1 on your own time, as well as figure 6.2.